Does your license need saving? Do the wise thing. Call Wise Man Lawyers. Does your license need saving? Do the wise thing. Call Wise Man Lawyers. Don't face that court alone. Let the Wise Man team get you back on the road. Does your license need saving? Do the wise thing. Call the Wise Man team at Wise Man Lawyers.
Alright, today I'm at Caboolture Magistrates Court. Client was charged with mid-range drink driving, reading at .138. Basically, the bracket for mid-range drink driving starts at .1, goes up to .149. So with a reading of .138, she's getting close to the top end. The high range starts at .15, and as I said, .138. It's not much shy of the top end being .149. Because she was mid-range and she hadn't lost her licence for any reason in the last 5 years, she was eligible to apply for a DUI drink driving work licence, but the short version is she wasn't going to lose her job over this. She was too valued a member of the organisation for anyone to be willing to sign an affidavit saying that she was going to lose her job. So she didn't want to apply for a work licence, so my job was one of getting the disqualification down as low as possible, as opposed to applying for a DUI drink driving work licence. Worst case scenario for mid-range drink driving is a 12-month loss of licence, mandatory minimum is 3 months. But as I've already said at the start, mid-range starts at .1, so if you've got a reading of .1, .12 thereabouts, getting the minimum 3 months can be reasonably straightforward. But the closer you get to the mid-range cut-off, the harder it is, and basically the closer you get to high range, the more highly unlikely it is that you'll get the minimum of 3 months. But that said, my job was one of getting the disqualification down as low as possible. Given what she does for a living, I'm not going to go into details, but there's a professional body attached to that profession that requires periodic renewals of memberships, etc. Various professional bodies have their own definitions of what it is to be a fit and proper person to be a part of that body, and a lot of the definitions don't distinguish between criminal offending or traffic offending. Drink driving is not a criminal offence, it's a traffic offence, but in the eyes of a lot of these bodies, they don't care. If you've been charged with any offence, that can jeopardise a person's ability to convince that body that they're a fit and proper person to be a part of it. So as much as my job was one of getting the disqualification down as low as possible, it was also one of trying to persuade the magistrate to exercise their discretion in not recording conviction. I had my client a 10-day reformatory course exposing her to the very real world consequences of drink driving, fatalities, massive injuries, catastrophic injuries, etc. I drafted affidavit materials for her to sign talking about what she learnt. I've got her to get character references based on a template that we give all of our clients, guiding the referees through who the references have got to be addressed to. There's no point writing to whom it may concern, because, you know, if it's not written to the magistrate, obviously the magistrate doesn't know that the person who wrote it knew it was being written for tendering to a magistrate. So it must be addressed to the presiding magistrate of the relevant court, and it also must state in there that the person writing the reference is aware of the charge. You know, anyone can say someone else is a great bloke if they don't know the full story. So if the references aren't addressed to the magistrate or the court and don't state in there that it's being written in full knowledge of the charge at hand, the magistrate's not going to give it any weight or consideration. In any event, I prepared my submissions before coming to court today. Met the client at court, we grabbed the conference room, ran through the procedure, what I was going to say, etc. I guided the magistrate through my client's background, her lack of history, you know, what she does for a living, the difficulties she's going to suffer while she's off the road, the difficulties she'll suffer if there's a conviction recorded, etc. Look, the short version is I was successful in persuading the magistrate not to go past 4 months. I did somewhat cheekily push for the minimum 3 months, but as I said at the start, there was no realistic expectation of that. So it was a case of getting it as close to the mandatory minimum as possible rather than dead on. But look, 4 months for a reading of 0.138, and keeping in mind high range, which starts at 0.15, is a minimum 6 months. So 4 months for 0.138 in my mind is very good. It's a hell of a lot less than the worst case scenario of 12 months, and it's a hell of a lot less than the 6 months plus that someone might get if they were to come to court by themselves or with a lawyer that doesn't specialise in Queensland traffic law. I was also successful in persuading the magistrate not to record a conviction. So 4 months disqualification, no conviction recorded, modest fine. Client's very happy. I'm Andrew Wiseman. Thanks for watching. Hi, I'm Andrew Wiseman from Wiseman Lawyers, Queensland's only truly dedicated drug, alcohol and traffic offence law firm. If you face loss of licence, loss of vehicle imprisonment or anything in between at any court in Queensland, we can and will help you today. This is our specialty. This is all we do. Give us a call, 1300 947 352. I look forward to helping you resolve your issue today.
Don't face that court alone.